06, albeit a rescript. The court's satisfied that the indictment, when read as a whole, is sufficient to give due notice, while the definition of a hoax device as conveyed by the statute is not expressly included in the indictment. The words that are used in the indictment do not contradict that definition. The citation to the statute is accurate and appropriate. The indictment stands. Let's take 5 minutes.
All right.
Now that Mr. Segadelli has joined us, we can proceed. Are the verdict slips sufficient as drafted?
Satisfied, Your Honor. Yes, Your Honor.
All right, let's bring down the jury.
Yes, Your Honor.
Counsel, take a look at this. This is the redacted 137B.
Satisfied.
Thank you.
Jurors entering, all rise, please. Please be seated.
Jurors, it has been my distinct privilege to preside at the trial of this case. Surely, it is my job to rule upon objections as they are made, to move the trial along in an orderly fashion, and above all, to give both sides a fair trial. Nowhere in that short job description does it say that I decide the case. I do not. I have no stake in the outcome, ladies and gentlemen. You and you alone are the judges of the facts in this case. Likewise, the attorneys have well-defined roles. It is their job to be advocates, to push and pull and tug upon the evidence, so that through their efforts, you're exposed to the many facets of the evidence. All the better for you to do your job as the judges of the facts. So please, don't hold it against them if they've perhaps inartfully phrased a question or two, or asked to see me at the side once too often. They're only doing their job so that you can better do yours. And shortly, it will be your job to deliberate upon the evidence and hopefully reach a verdict. You'll do that best when you stick to the evidence. The human emotions, bias, prejudice, sympathy, and more are all too common in our everyday lives, but they have no place in the jury room. Keep the human emotions out. Focus just on your evidence, and you will return a just verdict. Now, judges and lawyers are very fond of talking about two types of evidence: direct evidence and circumstantial evidence. And you can use both in the course of your deliberations. Direct evidence comes to you from the witness stand when someone says, I saw, I heard, I observed something, and I'm here to tell you about it. It's direct. It's, I guess you could say, it's straight from the horse's mouth. That may be an advantage, but it may also leave you with a disadvantage of your having to determine whether you believe the witness. Do you believe the report of that observation? Circumstantial evidence is a bit different. Sometimes there's a fact to be proven. Maybe there's some direct evidence about it, maybe there isn't. But there's also surrounding facts that have been proven to your satisfaction. And from those proven surrounding facts, you draw a reasonable, logical inference to get to the fact to be proven. That's the process of using circumstantial evidence. On the chance Good. It's been a long while since that last cup of coffee for you, and so close to having lunch. You might be looking up at me, asking yourself, what is he talking about? Now, if you find yourself in that position, let me give you a simple example of direct and circumstantial evidence. But don't let the simplicity of my example take away from the seriousness of what you're about to do as a deliberating jury. But in my little example, let's just assume the other day you knew you were coming in for your jury work, but you also knew you were going to the bowling league that evening, and you were in charge of refreshments. Now, my youngest jurors, stick with me, okay? You don't know, life could end up taking you to the bowling league someday, okay? So early that morning, you made a gorgeous chocolate cake, and you left it on the kitchen counter and came into your jury day. At the end of your jury day, you got home, you're heading into the kitchen, you're feeling pretty good. You know, you're on the way to the bowling league, that cake's gonna be a big hit. And as you go into the kitchen, you look over on the counter, and this is the cake with a piece. What do? Well, in my little example, you got two kids, okay? So you call those two urchins of yours down into the kitchen, and be patient. Life could give you two urchins in the kitchen someday, okay? Johnny comes running into the kitchen. He looks at the cake, he looks at you, and he says, I saw Susie take the piece of cake. There's your direct evidence. All you gotta figure out is whether you believe Johnny. Now, my example's a little tougher, because hard on the heels of Johnny comes Susie running into the kitchen saying, wait a minute, I saw Johnny take the piece of cake. Well, what do? In my example, you're the parents, so you know exactly what to do. You stare at them both, that's what you do. And over here in the corner of Johnny's mouth, it looks like chocolate frosting. And down the front of that t-shirt, why, it looks like cake crumbs. Stare at Susie. No frosting or cake crumbs about Susie. The surrounding facts, the frosting and the cake crumbs, by reasonable, logical inference, take you to a conclusion as to who took the piece of cake. It's the simple steps of reasoning you do every day in your life. Just because you came through that back door to be a juror, that machine downstairs doesn't suck your common sense out of you. Use it in the course of your deliberations, but use it with these cautions. Jurors are allowed to use direct evidence, circumstantial evidence, and reasonable inferences. Jurors cannot engage in guesswork or speculation. So, if you're going to use direct evidence, you've got to be satisfied that it's credible. If you're going to use circumstantial evidence, you've got to be satisfied that that surrounding fact has been proven to your satisfaction. Anything less than a proven fact is too shaky a foundation to support an inference. Next, you got to be sure that the inference you use is a reasonable, logical one that in everyday life takes you from that known fact to the fact to be proven. Anything less than a reasonable, logical inference, again, sets you off into guesswork or speculation. And finally, all of your credible direct evidence, circumstantial evidence, and the inferences you draw must amount to proof beyond a reasonable doubt if you are to convict. With those cautions, you may use direct evidence, circumstantial evidence, and reasonable inferences. Jurors, it is your job to determine the credibility of your evidence. You can believe some of what a witness says, all of what a witness says, or none of it. That's for you to determine. Likewise, simply because something's an exhibit doesn't give it immediate credibility. It's for you to decide. Do you believe all that it purports to be? Some of it or none of it? Sometimes it isn't what the witness says, but how he or she says it that gives you a clue to the witness's credibility. Certainly, you can examine the demeanor of the witness. the probability or improbability of what they reported, the opportunity the witness had to make the observation being related to you. You might consider the passage of time from when the observation was made until the testimony. Given that passage of time, is the observation appropriate under the passage of time? So the frankness or lack of frankness the witness might have, perhaps any bias shown on the part of the witness's own testimony or the rest of your evidence. You could consider whether the witness has any stake in the outcome of the case. You might consider whether, prior to coming in to testify, on an earlier occasion, the witness had said something else, either in a report or in a statement or in a recording of some kind. In short, you can use all of the tools that you use in your everyday life to decide who's telling you the truth and who isn't. Now, when I say who's telling you the truth and who isn't, obviously I'm asking you to distinguish the truth from the lie. But I'm also asking you to do something more subtle. And for those of you over 50, I know this has already happened to you. It's going to happen to you someday too. You're going to be in the supermarket, pushing the cart down the aisle. And as you round the top of the next aisle, you look down that next aisle. Down there is Bonnie. Now Bonnie's your neighbor, okay? So you say, "Hi Bonnie, how you doing?" And as you push the cart down that new aisle, you get closer and closer to Bonnie, and suddenly it dawns on you, that's not Bonnie. Were you lying? Of course not. But you made an error due to human frailty. And that too is very common in our everyday life. So please, weed out the truth from a lie, but also weed out the truth from a misapprehension due to human frailty. Once you figure out what's true, then you've got to give it its proper weight in your deliberations. Something could be very true and be of little use in getting to a verdict. Something else could be very true and go right to the heart of the matter. So give your credible evidence its proper weight in the course of your deliberations. Now, we've had witnesses in this case who have reported their observations, recipient witnesses, if you will. Sometimes in the law we call them lay witnesses. But we've also had other folks who have come in here and given us what the law calls expert testimony. Testimony that's based not only perhaps on an observation by that witness, but coupled with some learning or education or experience that that witness has, that gives that witness the opportunity to give an opinion. We've had those types of witnesses relative to some of the physical evidence. You know, was it a firearm? Was it this? Was it that? We've had a great deal of that evidence relative to psychology and psychiatry. Simply because the law uses that term expert witness doesn't give that witness any leg up on the issue of credibility. They are no different than lay witnesses. You as jurors determine the facts in this case. The expert witnesses don't. You've got to decide what's credible from the expert as well as from the lay witness. Consider their experience, their training, their education, and so on, their perspective, whether they have a motive to perhaps shape things a trifle. Consider their opinions. Look behind the opinion to the facts they say support that opinion. Are those facts that have been established to your satisfaction by the evidence? You know, if the fact that underlies the opinion really hasn't been shown to your satisfaction, then that tends to erode the opinion that is based on that fact as well. You are the judges of the facts. You size up the credibility of the experts. You can believe all of what an expert says, some of it, or none of it. That's for you to determine. This case is no different than any other case tried in a criminal court in the United States in two very important respects. These things that I'm about to talk about are so basic to the process. They're the foundation of our system of justice. The first thing that I want to talk to you about in that regard, I spoke to you about right after the indictments were read. It's the presumption of innocence. I'm sure you've heard the term. It's fundamental to what we do in criminal cases. This defendant, like every defendant in every case, is presumed to be innocent. That presumption of innocence was here when we started. The presumption of innocence is here right now as I speak with you, and it will go with you into the jury room. If in your final decision you unanimously decide as to any particular charge that the Commonwealth has proved every element of that charge beyond a reasonable doubt, then and only then may you convict. Because then and only then does the presumption of innocence cease. However, if in your final deliberation you reach the point where you conclude the government has failed to prove any one of the elements of a particular charge beyond a reasonable doubt, then in that instance the presumption of innocence retains all its vitality and requires a finding of not guilty. That's basically what we do. It's not some idle legal theory to be cast aside lightly. The fact that there were indictments is not part of your evidence. The fact that there may have been search warrants or police activity, that's in and of itself not part of the evidence, but may present evidence to you through the observations of these witnesses or what they collect. You stick to the evidence. Honor the presumption of innocence. The Commonwealth has proved every element beyond a reasonable doubt, then the presumption ceases. If they fail to prove any one of the elements beyond a reasonable doubt, then a not guilty is required. The second basic pillar of our criminal justice system is the very notion of proof beyond a reasonable doubt. Again, you've heard that term, I'm sure. So, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence, and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It's not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That was not enough. Instead, The evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, jurors, the only way a jury can return a verdict, whether it be a verdict of not guilty by lack of criminal responsibility, or guilty, is by unanimous vote of the 12 deliberating jurors. Unanimity is also a basic principle in our criminal system. So, to say that we need unanimity obviously suggests we need somebody in that room to count heads. And Ms. Chapman, would you be the floor lady of our jury?
I will.
You will? Oh, okay. You didn't get a raise, you know. You stand no greater than any other juror. But as the foreperson, I'm sure you're many years working in medical field and management have taught you, there'll be some in that room all too eager to speak. And why not? They heard the evidence. But please, be sure the shy, the reticent get to be heard as well. What the law asks of a jury is a full and fair discussion of the evidence. And there's great value in that full and fair discussion, because what you think, sir, about a particular fact may be quite different than what this woman thinks about the same fact. And by talking about it, you get to try it on for size. You get to feel it. You know, does it fit? Is it everything you expected it was? Does it wear well as you think about it? There's great value in that process, and it's to be encouraged, Madam Poor Lady. But when it's time to reach a verdict, each juror votes his or her conclusion as he or she has determined it to be based on the evidence. There are some 12 separate charges in this case. 12 allegations of crime. It's going to take quite a while to explain all 12 of them as to what the elements are. And of the 12, there are some of them that have multiple counts. So altogether, I think it's 30 total counts that you have to consider. So it's going to take a while to talk about that. But there is one overarching issue that applies to all 30 individual charges. And that is the issue of criminal responsibility. There will be, Madam Floor Lady, a separate verdict slip for every single one of the charges. On the verdict slip, there'll be a heading that states the charge, and it will give you some indication as to what it applies to. For example, there may be a charge of aggravated assault and battery by means of a dangerous weapon, and on the indictment form, one will say Lisa Trebnikova. One will say Anna Trebnikova. Another one will say Jared McDonald, to differentiate the charges. But on every verdict slip, there will be a box for not guilty. A box for not guilty, lack of criminal responsibility, and a box for guilty. On the murder slip, it will be a little more involved, but I'll get to that later. Because in every single instance, as to every single charge, the Commonwealth has the obligation of proving legal sanity. To prove the defendant guilty of any crime, the Commonwealth must prove beyond a reasonable doubt that the defendant was criminally responsible at the time the alleged crime was committed. The burden is not on the defendant to prove a lack of criminal responsibility. Under the law, the Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crime with which he is charged, and also that the defendant is criminally responsible for his conduct. Criminal responsibility is a legal term. A person is not criminally responsible for his conduct if he has a mental disease or defect, and as a result of that mental disease or defect lacks substantial capacity either to appreciate the criminality or wrongfulness of his conduct, or to conform his conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal medical diagnosis. The phrase mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the crimes, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If you have a reasonable doubt whether the defendant had a mental disease or defect at the time of the crimes, then you must determine whether, as a result of a mental disease or defect, he lacked substantial capacity either to appreciate the criminality or wrongfulness of his conduct, or to conform his conduct to the requirements of the law. To establish that the defendant has substantial capacity to conform his conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of his ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. The Commonwealth must prove that the defendant knew and understood that his conduct was illegal or that it was wrong. It is not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that his conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not provide the defendant of a meaningful understanding of the legal or moral significance of his conduct. The defendant must have been able to realize in some meaningful way that his conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that has been presented at this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. After the lunch break, I'm going to instruct you on the elements of the offenses that the Commonwealth alleges the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time the crimes were committed. That is, the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. First, that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect. Or second, that if the defendant did suffer from a mental disease or defect, or if there's a reasonable doubt as to whether he did suffer from a mental disease or defect, he nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of his conduct and to conform his conduct to the requirements of the law. As I have previously instructed, your decision should be based solely on the evidence and the law of this case. In any case that raises an issue of lack of criminal responsibility, you as jurors are entitled to know what happens to a defendant if he is found not guilty by reason of lack of criminal responsibility. First, the court may order the defendant to be hospitalized at a mental health facility for a period of observation and examination. During this observation period, or in any event within 60 days after the verdict of not guilty by reason of lack of criminal responsibility, the district attorney or other appropriate authorities may petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital. If the court concludes that the defendant is mentally ill and that his discharge would create a substantial likelihood of serious harm to himself or others, then the court will grant the petition and commit the defendant to a proper mental facility or to Bridgewater State Hospital, initially for a period of 6 months. At the end of the 6 months and every year thereafter, the court reviews the order of commitment. If the defendant is still suffering from a mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitments as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of his life. If at some point the defendant is no longer mentally ill and dangerous, the court will order him discharged from the mental health facility or from Bridgewater State Hospital after a hearing. The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. Jurors, those instructions regarding criminal responsibility apply to every one of the 30 charges that you will consider. In addition to proving beyond a reasonable doubt that the defendant is legally sane, that is, he is criminally responsible, the Commonwealth also has the burden of proving certain elements as to each of the charges. After the luncheon recess, I'm going to explain in detail the elements of the various charges. But first, lunch. Please go about lunch, and I will see you at 1:45. Please be in the jury room ready to go at 1:45.
All rise for the jurors.